As you know, when Chief Justice Roberts was nominated to the Supreme Court and sat in the seat you're currently in, he famously told this committee that judges are like umpires. Umpires don't make the rules, they apply them. He said that it was his job to call balls and strikes. And I was wondering if you could just talk about that metaphor. Do you think the balls and strikes analogy is a useful one, and does it have its limits?
Senator Klobuchar, I think it's correct in several important respects, but like all metaphors, it does have its limits. So let me start with the ways in which I think it's an apt metaphor. The first is kind of the most obvious, which is that you expect that the judge, as you expect the umpire, not to have a team in the game. In other words, not to come onto the field rooting for one team or another. You know, if the umpire comes on and says, you know, I want every call to go to the Phillies, that's a bad umpire. And is that your team?
Not exactly. The Twins. The Twins.
I was pointing to Senator Kagan. I'm sorry. And same for the judge. So you know, to the extent that what the umpire suggests, that there's got to be neutrality, that there's got to be fairness to both parties, of course that's right. The second thing that I think is right about the metaphor, and I think that this is what the Chief Justice most had in mind, if I remember his testimony correctly, is that judges should realize that they're not the most important people in our democratic system of government. They have an important role. Of course they do. We live in a constitutional democracy, not a pure democracy. And judges have an important role in policing the constitutional boundaries of our system and ensuring that governmental actors, other governmental actors, don't overstep their proper role. But judges should recognize that that's a limited role, and that the policymakers of this country and that the people who make the fundamental decisions for this country are the people and their elected representatives, whether in Congress or in the executive branch. And I think that that's right, too, as I've tried to say on many occasions throughout these hearings. I suppose the way in which I think that the metaphor does have its limits, and I believe that this is in line with what Mr. Ayers was talking about, was that the metaphor might suggest to some people that law is a kind of robotic enterprise, that there's a kind of automatic quality to it, that it's easy, that we just sort of stand there and, you know, we go ball and strike and everything is clear-cut, and that there's no judgment in the process. And I do think that that's not right, and it's especially not right at the Supreme Court level, where the hardest cases go, and the cases that have been the subject of most dispute go. And as to that, I think that there is, judges do, in many of these cases, have to exercise judgment. They're not easy calls. That doesn't mean that they're doing anything other than applying law. I said yesterday on a couple of different occasions, it's law all the way down. You know, you're looking at text, you're looking at structure, you're looking at history, you're looking at precedent. You're looking at law and only at law, not your political preferences, not your personal preferences. But we do know that not every case is decided 9-0, and that's not because anybody's acting in bad faith. It's because those legal judgments are ones in which reasonable people can reasonably disagree sometimes. And so in that sense, law does require a kind of judgment, a kind of wisdom.